What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly Case Update. I'm a little under the weather. I got a slight cold, but that's okay. I'm here to bring you the cases. So I got a few interesting ones this week. The first one is Loumpos versus Bank One. It's out of the second DCA. This has to do with garnishing bank accounts. A lot of times we have cases where perhaps an equal distribution or for whatever reason you try to garnish a bank account and it's owned by the former spouse and say his new spouse. And the question becomes, is it owned by him as tenants by the entireties? In which case you can only collect and garnish the bank account if there's a judgment against both him and his new spouse together, or is it owned by the two of them as perhaps joint tenants with rights of survivorship, in which case you can still go after the husband or former husband's 50% interest. So in the second DCA, they decided that this takes us back to law school, right? So in order to have a tenants by the entireties account, what do you need to normally have under common law? It's like the Captain Planet, or you need everything to come together at once. You need unities of possession, interest, time, title, survivorship, and marriage. So you have to form the tenants by the entireties account at the same time as the person who establishes the account establishes the account. So in other words, in this case, the person was the husband basically. He established the account at some point in the year, earlier in the year, and then later, a few months later, he added his wife to the account and signed a signature card as tenants by the entireties. So there was a case law. There was a case under the Florida Supreme Court called Beal Bank, and basically that said that it made it so that in bank cases, when you're creating a bank account, same way that you would do when you're creating a real property, it's basically presumed if the parties own a bank account at the same time, it's presumed that they're going to be owning it as tenants by the entireties unless the account statement or the signature card or something says otherwise. So it's like the burden is on the other side to prove that this was not intended to be tenants by the entireties. Well, and then there's also a statute 655.791, which essentially codifies that and makes it so that if you have your name on the signature account, unless it specifically says this is not tenants by the entireties, it's going to be tenants by the entireties. So the question is, do you still have to have those common law, earth, wind, fire, possession, interest, time, title, survivorship, marriage? You still have to have all of those together at the same time in order to form a valid tenants by the entireties bank account? Well, the second DCA said yes, and they actually certified conflict with the fourth DCA. So this could be decided by the Florida Supreme Court. It's an interesting issue because then this has a big implications. And I know a lot of times I try to collect on behalf of my clients to try to collect against a bank account. And they say, no, this is tenants by the entireties. Can't collect against it. Well, you may want to check to see how that account was actually established because it may not actually be a valid tenants by the entireties account. Second case is Wells versus Wells. This is out of the first DCA. This takes us back to, I talked about this a few weeks ago, but basically the new rule for general magistrates, relatively new, is now you no longer do a report and recommendations and then have the general magistrate file that report, and then you have a certain amount of time to take exceptions to the report, file your exceptions, and then there's a hearing on the exceptions. Procedure has changed now. It's instead of doing that, you file the general magistrate files a recommended order to the court, or that doesn't necessarily even have to file it. They basically just present it to the court, their recommended order, general magistrate's recommended order, and then the court is supposed to promptly enter that order. Then you have now 15 days to file a motion to vacate that order if you're disagreeing with it. This case, unfortunately, the parties were kind of caught because this was really early on when this rule just came out, and the court actually got it wrong. But bottom line is, if it's going to be a final order, if it's like a general magistrate ruling on, let's say, a divorce, and it's a final order in the case, whatever it is, as long as it's a final order, got to make sure that you either, number one, file a motion to vacate timely, file a motion to vacate that order, recommended order timely, or number two, take an appeal. Because if you wait too long, what this person did was they filed what they thought were their exceptions to the report, thinking they had additional time for the court to actually rule on the exceptions, but it was a different procedure. They need to file a motion to vacate the order. If you don't do that and you don't timely take your appeal within 30 days, you could be out of luck and get your appeal dismissed, which is exactly what happened here. Last case I have is Izard versus Bois or Bois. It's out of the 4th DCA, and basically this is a 57-105 motion where essentially the former wife, filed a motion saying that the former husband was interfering with her time sharing because he was going to the child's extracurricular activities and basically like giving him a snack at the extracurricular activities and giving, following him, sort of talking to him afterwards and following him to his next activity to make sure, I guess, that he was safe because he had to ride his bike home or to the new activity. But the former wife basically said, no, you're interfering with my time sharing. She filed a motion for contempt. The former husband filed a motion for 57-105 fees, saying this was frivolous. Nowhere in the parenting plan or anywhere did it say that he couldn't go to the extracurricular activities or he couldn't talk with the child there or anything like that. So essentially, he won. The motion for contempt was denied, and then his motion for fees under 57-105 was granted. But unfortunately, the trial court did not make the findings necessary for a 57-105 attorney's fees order. You still, pursuant to the statute, you need to have findings saying essentially why this was frivolous, why this was without any merit in the law or the facts. Could be either one, basically. So didn't have those specific findings, so no good, got reversed. So make sure if you're doing a 57-105 motion and you want an order on it, make sure you include proposed findings in your order. All right, guys, that's it for this week. Hopefully I feel better. Take care, everybody.